can please be seated. Judging this final rounds, we have Honorable Mr. Justice N. Satish Kumar, who was appointed as District Judge entry level on regular basis on 6/6/2005 by way of direct recruitment. His Lordship was appointed as Additional Judge of this Honorable Court on 16/11/2016 and became a permanent judge on 2/11/2018. We have Honorable Dr. Justice R.N. Manjula, who was enrolled as an advocate in the year 1987 after finishing a law degree. Her Lordship got post-graduation degrees in law, Master of Human Rights and Women's Studies. Her Ladyship joined in the Tamil Nadu State Judicial Service in the year 1995 as a Junior Division Civil Judge and worked in several places across Tamil Nadu in various capacities for the past 3 decades. Her Ladyship was appointed as an Additional Judge of this Honorable Court on 3/12/2020 and became a permanent judge on 31/5/2022. Her Ladyship has been conferred with Doctor of Philosophy in Women's Studies by the Bharatidasan University, Trichy, in the year 2005 for the thesis on prevalence of suicidal ideation among students of higher education institutions in Chennai, an analysis from gender and perspective.
Honorable Justice D. Bharata Chakravarti graduated in law from Dr. Ambedkar Government Law College, Puducherry. His Lordship was a general practitioner conducting litigation at the Honorable Madras High Court, tribunals and subordinate courts at Chennai. His Lordship practiced along with his colleagues, Mr. T. Sai Krishnan and Honorable Mr. Justice G.K. Ilantarian, as a law firm Sai Bharat and Ilan. His Lordship served as a public prosecutor for the Union Territory of Puducherry at the Madras High Court. His Lordship is an accredited mediator and has authored several articles. Next, Honorable Mr. Justice Mohammad Shafiq enrolled as an advocate on 30/9/1994. Though his primary areas of practice are constitution and taxation, his practice also extended to environmental, commercial and telecommunication laws. He has appeared in over 10 high courts, including chartered high courts at Madras, Bombay and Calcutta. His Lordship was appointed as a special government pleader taxes for the state of Tamil Nadu in October 2018 till his elevation. Thank you. Lordships, can we start the rounds, Lordship? Yes. We request all the students, participants and all members of the audience to kindly keep their phones on silent mode or switched off. Thank you. The rounds may start as per their Lordships.
May it please this Honorable Court, this is the Council appearing on behalf of the appellant in the case of Aaron versus State and another. Before we begin, if it is of no inconvenience to Her Ladyship, may I collectively address the bench as Your Lordships? Yes. Much obliged, Your Ladyship. Would Your Lordships appreciate a brief perusal of the facts, or may the Council move on to the issues, Your Lordship? Move on to the issues. Much obliged, Your Lordships. Your Lordships, we understand that in the present matter from the factual proposition, there are multiple issues that come before this court. However, Your Lordships, for the brevity of arguments, the present council has divided these issues into 2 broad limbs. The first one, Your Lordships, being the question of law, that is the constitutionality of section 63 of the Bharatiya Sakshi Adhiniyam, which will be dealt by the present council, followed by the question on facts regarding the conviction of the appellant in the case, which will be dealt by my co-counsel. Before we begin, Your Lordships, may I please present 2 compendiums. We regret that we are not able to supply 4 copies. Can I please request the bench to share these 2 copies, Your Lordships? With the permission of Your Lordships, may I move on to my arguments? Much obliged, Your Lordships. Your Lordships, the first issue at hand is whether section 63 of the Bharatiya Sakshi Adhiniyam is unconstitutional and whether it adequately governs AI evidence. Your Lordships, it is most humbly submitted before this court that this section is unconstitutional insofar as it creates a blanket presumption of reliability on electronic evidences, which courts have interpreted to include AI evidence. The same, Your Lordships, I will be substantiating in 3 broad limbs. The first one, Your Lordships, being the violations to Article 21 of the Constitution of Indica. Your Lordships, it is humbly submitted that electronic evidence is deterministic, whereas AI evidence is probabilistic. Therefore, your lordships, if I may please place reliance to the case of Selvi versus State of Karnataka, which is the first judgment in the compendium submitted. Your lordships, we understand that this case dealt with the constitutionality of narco-analysis tests and polygraph tests. But the reason, your lordships, for declaring that these tests were unconstitutional was that there is scientific unreliability while these tests are concerned, and that, your lordships, in that court it was held that scientific unreliability of these tests would mean that Article 21 is violated. In the present case, your lordships, AI evidence, especially deepfake technology or facial recognition matches, they purport to deliver scientific certainty. However, your lordships, these are black box algorithms of which often proprietorship is with private parties, therefore they cannot be questioned or they cannot be brought before this court. The algorithms that they work on are often opaque structures that cannot be questioned, your lordships. Therefore, that brings us to the conclusion that there is a certain sort of unreliability in evidence that are generated by AI. There is a gap, your lordships, where we are allowing for courts to admit evidences which we know have probable value and not deterministic value. This, your lordships, placed with the fact that the right to confrontation is not a mere procedural law, but rather it is rooted in Article 21's guarantee of a free trial. Even in the very landmark judgment of Kartar Singh versus State of Punjab, it was held that cross-examination is the acid test of truth. Therefore, your lordships, when the prosecution relies on these AI evidences, which they themselves sometimes do not know what the algorithm behind it is, what the system behind it is, and then when the law does not have a mandate to question these algorithms, to question how the AI has come to these conclusions, there is a gross violation of Article 21, your lordships. This brings me, your lordships, to my second contention regarding with violations to Article 14 of the Constitution. Your lordships, it is most humbly submitted that Article 14, it prohibits laws, procedures that allow for discriminatory biases and arbitrariness. Your lordships, AI models as a whole are not neutral. And this has been held, your lordships. This might be a very technical argument, but I would still like to put this before this court. Your lordships, in India, we've not had a research like this yet. However, in countries like the US, the UK, Stanford, MIT, they have researched, they have done an analysis of when AI models are developed in their nations, do these AI models, do they mirror the discriminatory biases in that region? For example, in the United States, say there is a discriminatory bias towards dark-skinned people. So the proposition of their research was, when AI models are being made in the United States of America, are these biases mirrored? Your lordships, it is in the compendium as well, your lordships, the research has been submitted, whereas the court, the research concluded by saying that yes, there is a bias. And the bias on two folds, on gender and on color discrimination. It is page 16 of the compendium submitted, your lordships. What it said is that when judicial use was given to these AI models, if it could convict a man or a woman, it had a bias towards a man and it convicted the woman. Or if it was a white person or a black person, it convicted the black person instead of the white person. Because these are inherent biases that exist in the United States of America. Similar researchers, your lordships, in the MIT, in Stanford, they said genders have been a lot of bias regarding genders, race, communities, majorities and minorities of that nation. Now, applying this technical know-how that we have on the Indian criminal jurisprudence, your lordships, we are a country where there is a huge classification. Discrimination goes on all grounds. Therefore, your lordships, when we know that these AI models can probably have these biases, there is a very certain probability that these biases will be shown in the results. These results are now being produced before the court. They are being interpreted into Section 63, saying that they come within the ambit of electronic evidence. There is no procedural safeguard, or there is no procedural guidelines as to how these AI evidences can be questioned, what the procedure behind them is. Your Lordships, we believe that falls absolutely flat of all constitutional safeguards that this country has to offer. I'm unable to hear you, Your Lordships.
Now, your argument is that there are two defects you have pointed out in your arguments. First, you say that we don't have the wherewithal to, differentiate, or the algorithms we don't have to differentiate between the truth or the deep fake. Second, you are saying they will have the biases. All right, taking that as to be correct, what should be the approach of the court? Approach of the criminal law should be to get into the truth, or should we shun the evidence itself in toto?
Your Lordships, we agree that the criminal courts must endeavor to pursue the truth. However, Your Lordships, the contention of this council...
Where do you find the truth? The courts has to find out the truth.
Certainly, Your Lordships...
Where do you find it?
Your Lordships, that is the very contention of this council, Your Lordships, that truth, there is no procedure to establish the truth. There is no...
Is there any provision of law to say that the courts endeavor to find out the truth?
Your Lordships, the Constitution itself provides, Your Lordships, under Article 21, the right to a fair trial. Therefore, Your Lordships, and various constitutions...
These are the safeguards guaranteed under the Constitution. But the trial is governed by the Evidence Act, now the BSA. Is the Evidence Act declares that the truth should be found out by the courts, or what should be seen by the courts?
Your Lordships, if I may give an example, in Section 63 itself, we are not contesting that the procedure for electronic records is wrong. We are contesting that the interpretation of adding AI into its ambit is wrong. To answer Your Lordship's question, Section 63 itself provides for certifications for electronic records to be brought into the picture. Therefore, Your Lordships, every provision of the Evidence Act, it lays down a procedure regarding how it will be admitted. That is, if this procedure is followed, these documents will be admitted as true. That is the very contention of this council, Your Lordships, that procedure is absent when it comes to AI-generated evidence.
In other words, your case is that, just as Justice Bharat Chakravarti said, do you do away with this evidence? Your answer is yes. That's the reason why you're challenging the validity. Otherwise, you won't be challenging the validity. Now, you don't have to water down your arguments. Therefore, you could stick on to your argument that it would result, if you also permit AI evidence, then it is going to be violation of 21 and therefore exclude AI evidence.
Certainly, Your Lordships, we wish...
What is the charge against you? The specific charge that you have created a AI-powered evidence system.
Your Lordships, if I may clarify with the propositional matrix, this AI admissibility that we are challenging is certainly not the records that the software of the petitioner. Paragraph 15 of the moot proposition, Your Lordships, makes it very clear as to what evidence did the courts place heavy reliance on when it came to convicting Aaron. And if I may read out, Your Lordships...
1 second before proceeding. See, all along you have been putting forth your argument about the unconstitutionality. You claim that it is unconstitutional. 63, admitting electronic evidence and including AI in that. And you said two reasons for that. One is its probabilized value and it is not a confirmative evidence. Other, you said that it is biased in terms of gender and race and color. And you say that these things, whether the admission or even reliance of this AI evidence, whether it is for confirmation or for probabilization, what is the evidentiary value according to you?
Thank you for your question, Your Ladyship. Your Ladyship, in the trial court, these AI automated decisions or reports, they had a convicting value. That is, the court relied upon them to convict the petitioner. If I may just read out, Your Lordship.
I'll put it much more clear. Do you consider this evidence as a corroborative piece of one, or do you consider that this is going to be the substantive piece which is going to determine the decision?
Much obliged for the question, Your Ladyship. Your Ladyship, we would like to submit that we are not against the fact that AI evidence, whether it should be corroborative or whether it should be substantial. However, Your Ladyship, we would like to clarify. Your Ladyship, if you can just rephrase your question a little bit.
No, I just wanted you to clarify. See, when you call something as unconstitutional, that is, it should be shunned even at the threshold. All right? If that be your case, do you consider this kind of evidence as that of a corroborative piece which is going to help collecting more evidence and not relying the decision only basing on this, or whether you consider yourself that AI is going to play a prominent part and only based on AI evidence the court is going to render its judgment?
Thank you for repeating the question.
Have I made myself clear now at least?
Yes,
Correct?
Your Ladyship. I'm very sorry for
No
making you
problem.
have to repeat. Your Lordships, my time is up. Can I please ask for an extension of 2 minutes to complete?
All right, because
Much.
it's our question, yes.
Your Ladyship, if I were to answer that question, we certainly, in the present case, Your Lordships, it has been used substantially to convict the petitioner. However, Your Lordships, our contention is that whether it is corroborative or whether it is the substantial evidence that is relied upon for conviction, whatever the court decides is, whatever the judges feel is right is okay, fine, Your Ladyship. However, the procedure for that should be established. That is, even if it is substantial evidence, even if that is the sole ground for conviction, there has to be a procedure followed. In the present case as well, Your Ladyship, paragraph 15 says that heavy reliance was on automated results derived by decision-making systems of the CCW. Therefore, that AI evidence, Your Ladyship, is not of the petitioner, but rather the cyber crime wing provided an AI-generated report. If I may corroborate this to the clarifications in question number 12, there was a clarification asked saying, is this automated, if I may read out exactly, Your Lordships, was the automated decision-making system mentioned in paragraph 15 powered by artificial intelligence? The answer is yes. Artificial intelligence was used for random number generation. This, Your Lordships, in fact, raises multiple more questions as to why the CCW had to randomly generate numbers. Is the clarification implying that the CCW generated the whole report, generated numbers and produced it before the court, and the trial court has admitted that evidence as substantially and convicted the petitioner, therefore, Your Lordship? So this factual premise further goes to prove of how, when there is a lack, as there is a lack of procedure for AI evidence, the results that follow, Your Lordships, the results that the judiciary, the trial courts might interpret section 63 in. Your Lordships, if you permit a minute, I would like to make my final contention,
Yes.
or I would like
I
to.
will have just one question.
Certainly.
See, you are looking at this particular case to decide the validity. The validity will not be decided generally on the basis of a particular case. Hard cases make bad law, and therefore when it comes to constitutionality, you look at the general application.
Certainly, Your Lordships, I agree with Your Lordships, which is why I did not make submissions regarding the factual matrix. I wish to answer the question. In fact, my argument regarding Article 14, the factual matrix does not propose a discriminatory bias, but that is what is again allowed when AI evidence is included into the interpretation of 63. I hope that clarified Your Lordship's question. Your Lordships, can I have a minute or may I leave? Your call.
Finish your arguments. Yes,
Sir-
consolidate.
Certainly, Your Lordships. I would like to end, Your Lordships, by simply quoting international jurisprudence on that matter. Your Lordships, take the OECD AI Principles of 2019, the UNESCO Recommendation on AI Ethics of 2021. All of them have one thing to say about the judicial use of AI. And they are very clear, Your Lordships, when they say that accountability, transparency, and human oversight are extremely essential when it comes to the judicial use of AI, all of which remains unsatiated in the present case, all of which is also most humbly submitted before this honorable court. If Your Lordships has any further questions, I would love to address them, Your Lordship.
Yes, you may remain.
Much obliged. It was a pleasure arguing before this court. I would like to leave for my co-counsel to continue.
But you have to address what is the charge you have been faced, why you have been convicted, what
Sir.
is the charge for a
That's why she asked.
Your Lordships, I'm dealing with the question of law, Your Lordships. My co-counsel will convince you on the question on merits.
Yes, yes.
May it please this honorable court. This is the co-counsel appearing on behalf of the appellant, my lords, and I'll be aiding this bench in the adjudication of the second issue, which is specifically pertaining to the factual proposition whether the conviction is liable to be set aside or not, my lords. If it is of no inconvenience to your ladyship, may the counsel please address the bench collectively as my
Yes,
lords.
yes, yes.
Much
For all-
obliged, my
for-
lords.
For everyone here, you need not repeat that.
Certainly, my lords. My lords, the council shall demonstrate as to the setting aside of the conviction alone, my lords. We will rely on two broad aspects. My lords, the first aspect shall be as to how the prosecution had failed to establish the integrity of its evidence, be it oral or digital. Or my lord, second ground is that the systematic lapses in procedure altogether and mere possession shall not account in mens rea at any point. My lords, if I may please have my time to elaborate each of these submissions in detail. My lords, my first limb of my argument shall pertain to the integrity of the evidence being fatally compromised. My lords, if I may please have your attention to the factual proposition, my lords. My lords, if I may please read the proposition.
Yes.
Much obliged, my lords. My lords, if I may have your attention to paragraph number 10 of the moot proposition, my lords. My lords, it bears the picture of Sir Natarajan on the... It's given in the kit, my lords.
This one.
The grey kit, my lords. The
Blue
brown
one.
color file inside, it has the proposition. copy, my lords.
Yes. Yes.
That's the clarification, my lords. There's another...
Yes, go ahead.
Sorry. Yes, yes. My lords, if I may please have your attention to paragraph number 10 of the proposition, my lords. It is with specific to Aaron's arrest and seizure. My lords, if I may please have your attention to the penultimate sentence, it reads that at the time of preparation of seizure mahazar, no witnesses were present. Now, my lords, I'm not conveniently ignoring the next sentence. Yes, his family members were definitely asked for, but it is not the duty of the arrested to give his family details to be present for the arrest for the mahazar. It is the duty of the investigation officer to ensure that witnesses are present to affirm the credibility of his seizure altogether. Now, my lords, with that being said, surrounding just this fact alone, that no mahazar witnesses were present, additionally, two other facts exist, my lords, which is raising significant questions as to the credibility of the seizure altogether. Now, my lords, if I may please have your attention to paragraph number 19 of the proposition, my lords. My lords, paragraph number 19 of the proposition reads that the forensic clones of the devices seized from the petitioner were not sealed in tamper-proof containers. Now, my lords, that is the second limb of the fact which we would request the bench to take note of. My lords, whatever was seized was seized. Yes, there were 3 laptops. Yes, there were 25 mobile devices. Yes, there was a hardware altogether. But my lords, the question is where where the same devices which were seized sent to the forensic laboratory. The answer is no. Now, my lords, this is not a mere submission I'm making. This is again revealing on facts. My lords, this is where the prosecution had gone wrong, we believe. My lords, it is handed to us that the hash values, when it was recorded at the time of seizure, had been recorded erroneously. And this also is the finding under paragraph 19. Now, my lords, the hash values are specifically the cloning values, my lords. My lords, if I may please have your attention to give a very simple analogy, my lords. Aadhaar number, we all have an Aadhaar number, a unique identification code. If it even differs by a single number, it can refer to a different person. The same way a hash value is for a digital device. It's a digital footprint. It cannot differ. If even by a single character it differs, it is totally referring to another object altogether. Now, my lords, if I may please have your attention, my lords, at the course of our research, we were able to find that our Madras High Court itself, a division bench comprising Justices Anand Venkatesh and Justice M.S. Ramesh have talked about how detailedly these hash values have to be dealt. If I may please have your attention to page number 34 of our compendium, my lords, the grey color file. Page number 34 of the compendium, my lords.
Your memorial, sir.
The compendium, my lords.
All right.
This one, the file.
Yes.
My lords, page number 34 bears the division bench order of our Honorable Madras High Court, my lords. My lords, that is the dictum laid down in Yuvraj versus State. If I may please, the relevant portion has been highlighted for the bench's brevity, my lords. If I may please quote the section.
Yes.
The relevant portion, to ensure that what is collected as an evidence in the source is exactly reflected or produced at the time of marking the electronic evidence before the court. So, my lords, it applies specifically to CCTV footages, but in altogether it records to all the electronic evidences. The concept of hash value is insisted at 4 stages, and this value must be the same on all those 4 stages to ensure authenticity. My lord, the division bench goes ahead to examine as to what are these 4 stages. In short, I'll keep it, my lords, which is 1, when the original evidence is being collected, you will record the hash value first time. Second, it has to be for the forensic image creation. You create a clone, ensure that the same hash values are being present again. Third is for the, when you send it to the forensic examination analysis, you have to record it for the 3rd time. And 4th is when the final report is being presented. 4 times the hash values have to be recorded, and in all the 4 times they have to be the same. And now, my lords, paragraph number 19 says that there is a misrecorded hash value altogether. Now, my lords.
Now, I was under the impression that the hash value will differ for each transaction.
Certainly, my lords. My lords,
It cannot be the same for all the 4 transactions.
certainly, my lords. My lords, paragraph 19 is specifically referring to the seizure of devices which were at Aaron's devices. And at that seizure, they recorded the hash values, which is what can be found in paragraph 19. For every transaction, it does valid. But then for every device, when they record the data inside, those also will have a hash
you opened
value.
your argument by saying, if the hash value differs, it should be from a different object. That's where I want to differ with you. Hash value will be the same for the same transaction. Even if the file is opened again or tampered with or anything is done, it will give a different hash value, even if it is in the same, from the same device or same person
Exactly,
or
my lords.
same this thing. Then how do you say that merely because the hash value differs, it must be from some other objects?
My lords, that is exactly where we believe the...
Now, otherwise, please clarify.
See, other one aspect, hash value is deferred in only one device. How many devices have been seized from you?
My lords, 25 mobile phones.
25 mobile phones, laptops have seized. There is a difference in only one device. Can you take advantage of that to say that there are no seizure is affected from you?
My lords, the devices were seized. We
Yes.
do not defend to the number of devices.
There is only the value is deferred in only one device, not in the entire devices seized from you.
Certainly,
So
my
what
lords.
is your explanation for that?
My lords, if I may please have your attention to the proposition paragraph. My lords, 2 seizures exist, my lords. One seizure had happened at TTPL. The second seizure had happened at Aaron's place. As to how TTPL seizure led to Aaron is again the factual proposition is silent on that. But however, the forensic analysis report which has come out is only one. My lords, that the content of the forensic analysis report can be found in paragraph number 12 of the proposition, my lords. And paragraph number J and paragraph number 10 gives us the note of 2 different seizures being present, which is at 2 different places at 2 different times. As of the seizure at TTPL is concerned, they have Mahazar witnesses, they have recorded the hash values right, nothing is debated over there. But however, on what was seized at Aaron's place, it was not. But the forensic analysis report talks about both the devices being sent together, and there's only one forensic analysis report. And my lords, this honorable bench made it clear that if there is a possible view which is favoring the accused and favoring the prosecution, beyond reasonable doubt is on them. We have the presumption of innocence, and the view which favors the accused has to be taken altogether. I mean, with that being said,
No, see, as my brother judge pointed out, first clarify about the difference in the hash value. See, suppose you say that the difference in the hash value itself earns you a benefit of doubt, then it's altogether a different argument.
certainly, my lords.
If hash value is bound to differ from an instrument to instrument, from one instrument to another instrument, or whenever you use it, each and every transaction, then there is no point in this argument.
I agree, my lords. My lords, when the devices were seized, at that time, they would have had an existent hash value. And as of their seizure is concerned, the hash value is recorded. Now, my lords, we put it in a tamper-proof box to ensure that it is not being opened. But again, the proposition is clear that it was not put in a tamper-proof box either. And it goes on to say that there were no Mahazar witnesses present. Now, my lords, the cherry on the top can be found in paragraph number 19. My lords, the proposition reads that, my lords, there is a recorded finding that the hash value was recorded wrong. Now, my lords, if it is sent to the forensics, it should have come as a mismatch. Now, paragraph number 19 reads that, by recording the hash values wrong of the seized devices, my lords, paragraph number 15, my lords, I'm so sorry. Paragraph 15, if I may quote the section, my lords, the trial commenced so and featured heavy reliance on digital evidence so and so. Now, my lords, the penultimate line reads as, witness testimony of forensic analysts who explained the hash match. Thereby, my lords, there is a recorded finding that there has been a hash mismatch. You have recorded the hash value wrong. Now, when your investigation officer is sending it to the forensic analysis, there should have been a mismatch. But however, the report is coming that it is all the more the same. Now, my lords, this coupled that there is a match of forensic analysis report. Now, my lords, this coupled with the fact that it was not put in a tamper-proof box, nor it had Caesar Mahazar present, and with the fact that there was indeed a mismatch, cannot have the forensic analysis report coming out it was matching. And that raises credible doubts with the presence of only one forensic analysis report. We cannot conclude that it was Aaron's. It could have been TTPL's as well. And TTPL is not even been made an accused. It is only Aaron who is present. And my lords, worst case scenario, the ultimate thing which we might have to take notice of that, after TTPL's raid, the facts directly jump to Aaron being arrested. They have nothing mentioned as to how TTPL Caesar had led to the way of Aaron. Aaron was an intern at that company before a long amount of time. He had graduated in IIT altogether, and now his previous internship has been caused as a reason for them to have stated, though you did have an internship at the company, and now you are responsible for leading the entire syndicate and siphoning some 76.5 crores, which we have no clue how did it even happen when your forensic analysis report and investigation itself is flawed. And all of that, my lords, together is raising significant doubts as to the Caesar itself. Well, if I may please move to the next limb of my argument, holding that the seizure was itself questioned, my lords. And my lords, with regards to that, whatever was seized at that particular place becomes the fruit of a poisonous tree. But my lords, fruit of the poisonous tree doctrine, as of India is concerned, we are aware that anything which is obtained illegally also can be admitted in the court as long as it is corroborative. But however, the credibility of the prosecution should be so good that the illegality aspects can be put down. My lords, we agree. Procedural justice is not above substantive justice. But however, if your substantive justice itself is not proven, or procedural justice is so bad that substantive justice cannot take amount, it cannot be done so. My lords, with that being said, may the council please move to the next limb of my arguments, my lords. They were, my lords, any factual findings of the forensic analysis report is requested not to be used, considering that the factual proposition is silent, and very most importantly, my lords, and both of them have one common report together. My lords, the second limb of my arguments shall pertain to the confession, my lords, which is extracted under duress. Now, my lords, the paragraph number 19, my lords, shall talk about what was extracted during the confession. It is alleged that it is to have been at the presence of not a lawyer, and very most importantly, it's under duress. Now, my lords, Justice Krishna here in Nandini Satpathy made it very clear that you cannot force someone to make a confession, and if at all you do so, and if they tend to redact it, if it is corroborative of value of whatever you have seized, it's agreeable. But my lords, if I may please have your attention, everything which was discussed here was before the investigation officer. Now, section 23 clause 1 and section 22 of the Bharatiya Sakshi Adhiniyam makes it clear that whatever you make before the investigation officer or police is not admissible. Whatever you tell before the judge is the truth. And that, my lords, makes it clear that the confession, if it's being challenged under duress, any statement which is made before the police investigation officer cannot be liable. On that grounds alone shall make it clear that whatever was put under as a confession, it was under duress, my lords. Thereby, the confession also shall not have any standing values, my lords. That brings me to the elephant in the room, my lords, which is the AI evidence, which on constitutionality aspect, my co-counsel has convinced the bench, I presume. But however, as to the factual aspects of how AI evidence has taken down, my lords, if you please have your attention, my lords, which is certainly the paragraph number 15 of the proposition, my lords. My lords, definitely, trusting the machine seems to be better than trusting CCW wing altogether. But the question of who built this algorithm of AI is the question. Is it a notified body under section 1790 of the Information Technology Act? Was the algorithm developed by people who were authentic enough, who knew what they were doing? Was this tested on other people? We do not know. It's not that the proposition is certainly silent, but then how many previous cases you had used to generate evidences using that is also not clear. But my lords, I'd request the bench to take notice of one clarification given, which is whether the decision making, the automated decision making system mentioned in paragraph 15 was powered by an artificial intelligence. The proposition drafter has answered yes. And therefore, my lords, they have used AI in decision making. My lords, AI can be used for drafting. AI can be used for anything. But in a prosecution cell, whereby you're penalizing a person for 14 years and imposing sanctions, you cannot make AI to take decisions. And that cannot be at any point tolerated, or my co-counsel had pointed out through OECD. OECD guidelines, it makes it clear that there has to be human intervention, and that cannot be relied as an evidence. Procedurally, my lords, Section 63(4), my lords, the BSA regime and the Indian Evidence Act. Indian Evidence Act, we had Anwar versus Bashir altogether, telling that for primary evidence you require for primary evidence you require the 63(4) certificate. For others you don't. But however, my lords, the legislature took cognizance of this, and then when they came up with the Bharatiya Sakshi Adhiniyam, they said no matter what primary evidence or secondary evidence, when you give a digital evidence, you give two certificates. First one is for integrity, second one is for identification. Therefore, my lords, identification shall not be a problem. But as to the integrity, is it the algorithm developer who will be put on stand for marking? We do not know. Is it the prompt giver who shall be put on stand? We do not know. But, and very most importantly, my lords, we did bring this to the knowledge of the Sessions Court. But however, the Sessions judge did not take our objection. They turned a deaf ear towards it, and they admitted the evidence. Nobody was put. And this can be clear, my lords. This can be found in clarification number 28, my lords, whereby the proposition drafter has answered that certificate under 63 of BSA was filed by the investigation officer, and no expert was notified on the date of its marking. Therefore, my lords, the integrity certificate, which is the mandate under 63(4), by procedurally itself went to be flawed. And going ahead, even if it is presumed that it is the algorithm developer, every time you rely on this algorithm, every time you rely on this decision-making system, would you call the algorithm developer on the stand? That would be a significant question which we'd have to raise. And very most importantly, an AI, if it's giving an input today, based on whatever knowledge it's incurring tomorrow, it will give you a different output tomorrow. And that cannot be relied upon.
In your case, the input that is given by the AI was based on the existing data, or it is something a generative, it itself generated the evidence?
My lords, its legal backing is what we are certainly questioning, my lords. As to the fact that CCW has put this algorithm inside their systems and they're making reports, as who did even authorize this algorithm, my lords? There is no executive order, there is no legislative notices which has mandated them.
Now, you have been engaged, you have created a system using the AI. You have a facts exclusive within your knowledge. Then how you will have to explain how it has happened, whether the algorithm itself captured, developed a new system, and the defect voices has been sent to the other accounts. All these things you will have to explain. Because you have been engaged to create a system. When you will have, first you will have to establish that whether the algorithm themselves developed and created such a system, or you have created a system. The burden lies on you to say.
My lords, the very contention which we would like to rely upon is that, my lords, my client is an AI and cyber security graduate from IIT. He did not design their automated decision system. Their automated decision system, God knows or they know who they've designed it. And we would not be able to clarify their algorithm or their authenticity. We very respectfully believe that it is them who would have to clarify, because it is them who had relied upon that particular evidence altogether. My lords, if I please have a minute to mind up my arguments altogether, my lords. My lords, with that being said, my lords, apart from the procedural non-compliance of 63(4) not even being given, we were not given the permission to even to conduct a cross-examination over the certificate, my lords. My lords, if I may please have your attention to paragraph number 20 of the proposition. It records our objection to the sessions, but not to the sessions, my lords, that it cannot be admitted unless cross-examined and validated by original algorithm developer. But it is unfortunate that the sessions did not take, and they took presumptibility under 63 and they admitted the evidence. And that evidence is significantly relied upon with the search and seizure altogether for them to have rendered this conviction upon us altogether. My lords, the last limb of my argument shall be on the charges which were imposed on us, my lords. My lords, as all of these charges arise as a fact of the seizure which had happened, which itself is questionable, along with the forensic analysis report and its conclusion, we believe that, but for arguendo purposes, if have to dwell inside the charges, we believe that there is an investigational overreach. My lords, there is an explicit use of section 113 for Terrorist Act. My lords, section Terrorist Act includes and necessitates the usage of explosive substances via the first subsection. And my lords, it does not deal with, it does not even arguendo purposes say that my client has some probable cause to have been believed that he has caused this. Terrorist Act is not essentially the section. All other sections which you have imposed, including cheating and forgery, including conspiracy, my lords. For conspiracy, you have to prove the agreement between all the parties. There is no evidence which the money mules along with the parties has not been established that way either. And now all the more this, I believe that there is so much public pressure arising out of this case that 72.5 crores has been alleged, and we believe this is all a framework altogether, my lords. And the fact that there is no connection between TTPL's raid and my client's raid is along with the seizure also being in significant question, all the more gives us the benefit of the doubt, and we pray the acquittal of in this particular instance, my lords. My lords, with that being said, may the council please move to the prayer of the...
Can I understand the sum of your argument in such a way that you are attacking the procedure adopted by the investigative agency to deduce whatever data that they can filtrate from the seized materials?
Certainly, my lords. The hash values which were recorded also were certain. The procedural irregularities exist, my lords. With that procedural irregularities, coupled with the fact that the forensic analysis report which they have submitted itself does not come to be matching, is raising questions to their seizure. First limb, my lords. Second limb of whatever the evidences that to just give a summary of...
You have been repeatedly saying that some AI is making decision at which end, for whose demand?
My lords, if I may please have your attention to the proposition itself, my lords. The proposition clarification makes it clear that for the trial courts, my lords, there is an observation that they relied upon an automated decision-making system. A clarification was asked to the proposition drafter as to what do you mean by this automated decision-making system? Did this involve AI? To which the proposition drafter answered yes. And the decision-making system, which is what the Sessions Court had relied upon on conviction, included AI. And upon decision making, it's for a judge. It's for a judge alone who can decide the impact assessment, who can judge the evidence altogether. Not some AI report who's based on an algorithm. My lords, if the algorithm is flawed, every output which it is producing can become flawed. And we cannot rely on that either.
But the question was, I think, this is only a piece of material which was looked into by the trial court. And therefore, ultimately, it's the trial court which would have decided. And maybe in your case they used it, they found that this material to be valid. In another case they may say, I'm not taking this as a piece of material evidence. Therefore, you can't say that this was something which is instrumental in the decision-making process. Apparently he exercised his discretion. I think that's broadly the question.
My lords, constitutionally, my lords, Vide Article 141, whatever the judgments of this honorable court are binding on all lower courts. If we set this as a precedent and we affirm that you can use AI, they'll outrightly use it altogether.
Therefore, you're saying, keep AI outside.
Certainly, my lord. AI does not cover 63.4. My lords, with that being said, our prayer is also drafted very carefully in a way, my lords, whereby we are invoking Article 142 for complete justice. We used Vishaka versus Rajasthan, whereby we came up with guidelines, interim guidelines to... My lords, with that being said, even our prayer is drafted in a way that it does not all the most... If we may please move to the prayer, my lords.
Yes.
Therefore, in light of the issues raised, arguments advanced and authorities cited, it is most humbly prayed before this honorable court to set aside the conviction passed by the Sessions Judge, affirmed by the High Court, and my lords, to strike down Section 63 as unconstitutional. But however, my lords, if Section 63, if being struck down, it will exclude electronic evidence too. By invoking doctrine of eclipse, we can strike down a specific portion, an operative portion of Section 63 alone to exclude AI evidence, my lords, or the provision can be read down in a way to exclude AI evidence. And under Article 142, to ensure complete justice, we can come up with interim guidelines until the legislature is coming up with specific provisions as to how AI evidences can be admitted, my lords. With that being said, or pass any other order or orders as this honorable court deems fit in the light of equity, goodness, and fair conscience. To all of which the petitioner shall be duty bound and forever pray. It was a pleasure arguing before my
Even
lords.
with regarding to your prayer, your entire grievance is inclusion of the AI evidence into the electronic records.
Certainly, my lords.
Authentication of the electronic records and the definition of electronic records are all contained in the Information Technology Act. Section 63 is only the procedural provision. If you don't want to, the AI evidence should be authenticated, should you not challenge the definition of electronic record or the provision of Section 5 under the Information Technology Act?
My lords, but that would invite the wrath of doctrine of overbreadth going on.
Those are
my
the
lords.
substantial provisions which say what is electronic record, which includes the AI generated records also. You want that only to exclude it. After all, Section 63 is only a method of authenticating those documents. You are on substantively on the very AI generated evidence itself.
My lords, AI has fortunately involved itself in all the aspects, my lords. But however, when it comes to evidences aspect, we'd have to stick to our evidence act. But however, electronic evidence will include any evidence generated by a computer resource program, which will include an AI. But it does not mean that it will come with a software development program, my lords. But for an AI, it's an algorithm. And it's proven that AI has a mind of its own.
Thank you. All right, thank you. Okay, welcome to law practice. Yes.
It is
Good.
not just
We
a
can ask you
skill-based
questions at
argument.
the end also. All right. Thank you.
Certainly, my lords. It was a pleasure arguing before
Thank
the bench, my
you.
lords.
It's a
What was
pleasure.
the defense you had taken in the trial?
My lords,
What is the defense you had taken?
my lords, as of the trial is concerned, my lords, it's pertinent to note that before the High Court, we had filed a 245 application. But very practically speaking, my lords, that is a fact which is lying against us in the proposition. But in the essence of moot, I'm bringing it forward. But I'll say a practical defense which I'll say is that we were engaged only for the Apex Court practice and we had given instructions to withdraw that 245 application.
No. Trial is already over. What is your defense in the trial court?
My lords, we have relied upon ethical hacker defense for over there, my lords. But again, my lords, ethical hacker altogether, on this factual finding which we have relied upon, or we are questioning the seizure and forensic analysis,
So
my lords.
ethical hacker defense you have taken, once you have taken, so you admit that you hacked it for
Presumption is there.
for providing a better system.
My lords, the ethical hacking defense, my lords, altogether in India is not really a recognized defense altogether. But however, at the later part, when we had figured out that the penetration testing was indeed in the process of being committed, TTPL could have easily assumed to that hacking
Okay, we'll come.
process
We'll come
altogether.
back. Yes.
Sorry.
Yes.
Greetings to the bench. Am I audible, Your Lordships?
Yes.
Much obliged. The council would like to submit 2 copies of the compendium. We kindly apologize for not being able to provide the bench with 4.
So all typesets are practice
Welcome to
here
law
started.
Yes.
In moot itself they were started. Typeset culture. Yes. Yes.
May it please the Honorable Court, this is Counsel number 1 appearing on behalf of the respondents in the case of Aaron versus the state and others. My Lordships, for the sake of the moot, we have divided the entire proposition into 3 issues. The first and second issue will be dealt by Counsel number 1, and the third issue will be dealt by Counsel number 2, my Lordships. For the sake of completeness and in deference to the record, the Council would like to briefly contest on maintainability, my Lords. With your permission, my Lords, much obliged, my Lords. The respondent humbly submits before the Supreme Court of Indica that we are here in this court today because of the invocation of Article 136 of the Constitution, my lords. Special leave petition should only be admitted in extraordinary circumstances where there is a miscarriage of justice or substantial question of law involved, my lords. In this case, the respondents would like to contend that the lower courts have appreciated all the evidences positively and they have also followed due procedure, and therefore the respondents find that there is no need to admit this petition, but for the sake of the proposition, we submit to the jurisdiction of the Supreme Court, and the Council would now like to proceed to the merits of the...
But they are attacking the constitutional validity also.
Indeed,
And
my...
in violation of Article 21.
Indeed, my lords,
And
indeed, my
therefore,
lords.
when the connected matter is coming, should it not be entertained?
We contend that their issue on constitutionality is baseless, and that will be dealt in detail by my counsel number 2. For the sake of the moot, we are submitting to the jurisdiction of the Supreme Court of Indica, my lords.
Yes.
Much obliged, my lords. I will be dealing with the second issue, which deals with the question of facts and the merits of the case, my lords. Much obliged. My lordships, the counsel for the respondent submits that the petitioner and the appellant in this case has been justly convicted under all of the concerned sections of the BNS, the IT Act, and the Aadhaar Act. The concerned sections are 111, 113, 318, 3192, 336, 340, and 61 of the BNS, and Section 66C, 66D, 72A of the Information Technology Act, as well as Sections 39 and 42 of the Aadhaar Act, my lords. Your lords, the conviction is based on all of the comprehensive evidence submitted by the prosecution and the respondents in the previous stages of the case, my lords. My lords, I would first like to contest on all of the evidences submitted. May I guide your lordships to para number 10 of the moot proposition,
Yes.
which deals with the evidences seized from Aaron's residence, my lords. My lords, it is an established fact that just because independent witnesses were not present during recovery does not vitiate the evidence that was recovered. This is contested on two grounds, my lords. If we observe paragraph number 10, we understand that seizure mahazar, which is the procedure of recovery, has happened. And this is done by an official or an official person. And we have to understand that in this case, the official or official person is either the police officer or the investigating officer himself. And there are n number of judgments. If I could respectfully guide the lordships to the page number 5 of the compendium submitted by the respondents, page number 5, my lordships, I have cited Kripal Singh case.
Yes.
Where the testimony given by the police officer or the person who has done the process of seizure mahazar himself is taken enough to testify the veracity of the evidences recovered from that place, my lordships. And if in case we make a difference between independent witnesses and the testimonies of official witnesses, we are undermining the trust the people have in the police administration in this country, my lordships, because we are raising a belief that the evidence or testimonies submitted by these official witnesses are itself in false, and that is not something that we should take forward as the apex court of this country, my lords. The council has also cited Govindaraju case in page number 8, which deals with how this would affect the police administration belief of the citizens of this country, my lords. In addition to this, may I guide your lordships kindly to clarification number 18 in the clarification number 18 in the clarifications provided, my lords. It says that the entire seizure mahazar process which happened in Aaron's residence was done under audio-video recordings, my
See,
lords.
the police officer's evidence can be relied upon for the fact that I went there, I seized it, to that extent only. The argument of the other side is on the content of the seizure. What was seized, whether the same seized material was sent to for sampling analysis, or how far the sampling analysis can be relied upon. It is not the act of seizure that is questioned. What is seized is the subject matter of debate.
Indeed, my lords, their contention is that because the procedure is so flawed when it comes to seizing, there is no substantial flow that this evidence that has been collected from the residence is one that has been submitted. But may I guide your lordships to paragraph number 15, which conclusively states that these evidence, if the honorable court chooses to accept them, establish all of the facts which the petitioners have been convicted under, my lords. And again, my lords, may I direct your attention to clarification number 18 of the clarifications provided. It says that the entire seizure recovery process was recorded with audio-video means, which this is done in addition to the independent witness being the police officer present in the scene of recovery, my lords. If I may kindly pass on this judgment copy here, my lords. My lords, I apologize for the first copy. It's the second copy that I should pass.
Yes. Yes.
Kindly again apologize for only providing the bench
Doesn't-
with one copy, my
doesn't-
lords.
Yes.
Doesn't.
In that case, it can be understood that with the innovations in technology, audio-video means came as an addition to what is already present in the evidence system of what can be veracitated and what can be authentically said that this is the evidence recorded. The fact that the entire seizure was recorded in audio-video means again adds to the veracity of the evidence submitted by the prosecution in the trial and high court. Therefore, the contention on behalf of the petitioners that the seizure from Aaron's house is completely baseless is now denied, my lordships. May I again guide your lordships to clarification number 36. The evidence seized from Aaron's house are the most prominent piece of evidence that links Aaron's activities to the syndicate. It is clearly stated in clarification number 36 that the devices seized from Aaron's residence link his activities to that of the syndicate, therefore establishing the entire case against him, my lords. And because of that, paragraph number 15, whatever findings have been recovered from all of these devices are also equivocably applicable to Aaron in this case, my lords. Now, Coming to the second set of devices that have been recovered from TTPL's co-working space, my lords. If I may guide your lordships to para number 8J of the moot proposition, my lords. In this case, as your lordship rightfully pointed out of all of the devices that have been recovered, it was one device's hash value that was not taken into consideration and which was mismatched, my lords. Even if we eliminate that one piece of evidence, the prosecution in this case has still rest of the evidences to establish a case against the petitioners in this case, my lords, which is very highly established in paragraph number 15. And in n number of criminal cases and in n number of criminal judgments, it is understood that a mere procedural error does not vitiate the entire trial, and because of one evidence having a mismatch value, we cannot disregard all of the other evidences that produced a substantive guilt here on part of the petitioner, my lords. May I guide my lordships to the other judgment copy that I submitted, which is Iqbal Ismail Sodawala versus State of Maharashtra, which conclusively established the fact that mere procedural errors do not vitiate the trial in entirety, or one evidence being in question does not vitiate the veracity and the credibility of other evidences produced by the prosecution, my lords. My lords, I would also like to add another point here. If we chronologically look at the moot proposition, the recovery from TTPL's co-working space was first, followed by the recovery from Aaron's co-working space. If we understand this in a chronological way, we can link that the recovery from TTPL is the most essential criteria for linking the entire crime to Aaron. The seizure there has led ultimately the investigating officer and the police to the recovery that has happened in Aaron's house, my lords. Therefore, both of these evidence alone itself provide a comprehensive case against Aaron here, my lords. Thirdly, coming to TTPL, my lords. My lords, this is a criminal case. In criminal case, there is no concept of proper party or necessary party, my lords. Just because TTPL has not been called as a party in this case does not negate or vitiate the fact that the accused has done what he has done with overburdening evidence already sitting upon his head, my lords. And adding on to the fact, the petitioners have failed to establish how and why TTPL have to be included here, because as established in the case of Iridium, it can very well be understood by the principle of alter ego that only when the managing person of the company has committed a crime that is so closely associated with the corporation that the corporation should also be criminally liable for what they have done is when TTPL should be included as a party. The petitioners have completely failed on their part to establish, and therefore their contention that TTPL should also be a party is completely negated, my lords. Therefore, based on the comprehensive pieces of evidence that the council has already dealt with, along with the witness testimonials, there is a comprehensive case established on part of the petitioners in this case, my lords. Now, may I move on to the defense of the petitioners in this case, which they have raised before the trial court and high court, my lords.
I mean to say that the scientific evidence going along with the testimonies of witnesses as well, that the case is not based only on the scientific evidence.
Indeed, my lords. There is also the AI evidence, which is done by the automated decision-making system. Considering my co-counsel is dealing with section 63 as a whole, she will be dealing with that ambit of the evidence and conclusively establishing that all of the evidences seized together establish a case against the petitioners in this instant moot proposition, my lords. With your permission, may I move on to the defense that they have raised, my lords? Very much obliged, my lords. If I may again guide your lordships to para number 24 and 27 of the moot proposition, we can see that their main defense that they have relied on under the trial court and the high court is ethical hacking, my lords. My lords, the respondents refute their entire case on the basis of ethical hacking, saying that they do not have mens rea to commit this crime, my lords. My lords, the first and foremost principle of ethical penetration hacking is that they should have sought authorization, my lords. They did not even try to seek for any authorization to ethically hack into the entire system, my lords. This negates their entire defense of ethical penetration hacking, because that is the one aspect that makes them different from white hat hackers, my lord. Without having the requisite permission and authorization to do what they have done, they are nothing but black hat hackers hacking with a malicious intent to loot people's money, and this is further established by the fact that they have created an elaborate scene of events, starting from creating a fake website, employing money mules to withdraw money from the ATMs, along with transferring all of these money into cryptocurrency wallets. If I may again respectfully guide your lordships to page number 17 of the compendium, which deals with how cyber criminals withdraw money from the ATM, convert it into cryptocurrency and send it to international criminal syndicates abroad. And that is further established by the fact in para 15, which says Aaron's link with the international criminals abroad. All of this together say that his intentions are way beyond ethical hacking, and it is actually to loot people money. And here the final destination for this is clarification number 6, which says that Aaron and the syndicate have actually used the money, my lords. The fact that they have used the money completely negates this entire defense on their face, my lords. My lords, here there is also a need to distinguish intention from motive. The fact that he did not even seek authorization for any of his activities show that he very well knew what he was doing and what consequences what he does will render, my lords. That is the basis of what mens rea is, knowing what your actions will render. As stated in the case of Staples versus United States, where a defendant need not know that their conduct is illegal to be guilty of a crime. Rather, the defendant must be conscious of the facts that make his conduct fit the definition of offense. The fact that he never sought authorization, the fact that he did something so elaborate, the fact that he made money mules withdraw this money, the fact that he had converted them into cryptocurrency, show that he had no care for the pensioners of the country but just wanted to loot the money and self-serve himself, my lords. My lords, therefore, the council contends that he has rightly been charged under all of the sections of BNS. When we're talking about organized crime, my lords, the first and foremost requisite for organized crime is that there should be more than one prior charge sheets to be filed against the accused in the preceding 10 years, and cognizance should have been taken of the same, my lords. In this case, though Aaron has not been under any of the charge sheets, if we can check clarification number 3, it clearly states that the other members of the syndicate are undergoing trial in various other states of Indica, meaning by the case of Zakir Abdul Mirjakar versus State of Maharashtra, which states that Supreme Court reaffirmed that it is not necessary for multiple charge sheets to be filed against each individual alleged to be part of the syndicate. It is sufficient if more than one charge sheet has been filed against the organized crime syndicate as a whole. Therefore, because of clarification number 3 and clarification number 36, which establishes his link to the syndicate and how syndicate has been undergoing trials, he is definitely to be charged under organized crime as well, because he has committed cybercrime in this country. Now, when we come to terrorist activity, my lords, he has acted with the intent to threaten the security and economic security of the country, because it is almost 74 crores of amount of money that he has looted from these pensioners, along with breaching government websites which carry your my lordships, my time is over, but I seek another 2 minutes to conclusively establish how he has been convicted. Much obliged, my lordships. He has scraped publicly available data from government websites, which holds Aadhaar details of almost every citizen of this country. Aadhaar details provide unique identification to every citizen of the country. When a person is stealing all of that information to be used for his monetary malicious intents, it means the security afforded to every citizen of the country is being questioned here, my lords. This is how the security of the country is threatened, and economic security is threatened because he has looted 74 crores money and has established that this is an example of ethical penetration hacking, and this cannot be accepted in the Supreme Court, my lords. My lords, I would like to collectively deal with 318, 3192, 336 and 340, which all talk about cheating by personification, forgery and forgery using a forged document, my lords. All of this deal with a dishonest and malicious intent to cause loss or to cause harm or to cause loss of property to the other person, my lords. And all of these ingredients are fulfilled by way of his elaborate scheme to loot people's money and to cause loss to them, my lords. Therefore, all of these sections have also been fulfilled by the petitioners in this case, my lords. Finally, coming to conspiracy, my lords, by the fact that clarification number 36 and the comprehensive evidence submitted by the prosecution, we have established a case against Aaron that he has his link with the syndicate, and because of this he has caused all of the crimes that he has been accused of, and therefore he is rightfully charged under conspiracy. When we're talking about section 66E, section 6060 and 72A of the IT Act, we are talking about identity theft, cheating by personification and unlawful breach of contract. When we're talking about identity theft, my lordships, he has used deepfake AI to imitate other officials, government officials, as provided by the witness testimonies, and tried to loot their money. And this is how he has committed identity theft. When we're talking about cheating by personation, he has again used all of their bank account details that he has recovered during the deepfake phone calls, and use this bank account details to later loot all of their money, the money that they already have and the money that was going to be coming to through their UPI linked wallets. All of this has been stolen, my lords. And 72A, by engaging in an implied contract with all of these individuals, saying that he is calling them only for verification purposes under the guise of ethical hacking, he has again committed an implied breach of contract, because of which this section has also been satisfied. And when we're talking about section 39 of the Aadhaar Act, it again talks about breaching into government websites and recovering sensitive data, my lordships. And because of that, he has also committed this breach, my lords, because he has accessed into government websites under AI chatbots and recovered all of the Aadhaar details and caused a lot of problems to all of the citizens of the country, my lords. With this, the counsel for the respondents would like to submit that the respondents in this case have conclusively established a case against the petitioners, and we have proved beyond reasonable doubt that he has committed this crime, and we have also disputed their entire ethical hacking defense, my lords. It was an honor arguing before this court. If the bench has any questions.
Yes, you can remind. Next.
Thank you so much, my lords.
Yes.
Am I audible, Your Lordships? This is speaker number 2 for the respondent, who will be dealing with the final issue as to whether the admission of evidence was in accordance with the procedure established by law, Your Lordships. Here, the counsel would like to start off by stating that when a provision is supposed to be deemed unconstitutional, it must fall under the ambit of Article 13(2), Your Lordships. And to the extent of inconsistency, it may be deemed void, Your Lordships. But in this instant case, for any provision to be deemed unconstitutional, it must be violative of any Part 3 rights under that of the Constitution, Your Lordships. Here in this instant case, the counsel would like to further submit that there is no Part 3 violation under by admitting AI generated evidence under the ambit of section 63, Your Lordships. The counsel would like to further proceed on by referring Your Lordships to paragraph number 15 of the Moot Court Proposition and paragraph number 26 of the Moot Court Proposition, Your Lordships.
Yes.
If I may in verbatim read out the paragraph, Your Lordships, it clearly states that automated results derived by decision-making systems of the CCW, witness testimony of forensic analysts who explain the hash match of seized devices, and expert evidence from professors on working of facial spoofing was introduced as part of the evidence, Your Lordships. Further going on into paragraph number 26 of the said Moot Court Proposition, Your Lordships, it states that the petitioners in this instant case have filed an appeal before the High Court of Nagaland contesting the violation of Article 21, and that BNSS and BSA enabled a presumption of guilt by relying on machines without transparent accountability, that use of deep fake detection reports cannot be a substitute for human testimony. It is contended by the counsel for the respondents that this deep fake detection report in question was the one that was generated by that of the automated decision making systems, Your Lordships. Automated decision making systems here do not vitiate any of these proceedings conducted by the court is primarily due to the reason that it does not make a decision with respect to the guilt or the acquittal of the instant petitioner in this case, Your Lordships. For example, if the petitioner may state the case of State versus Loomis, where an AI device was used to determine the guilt or the sentencing done for a prisoner under the AI ambit of under the AI algorithm of Compass, Your Lordships. That in itself was allowed to be valid by the Wisconsin court, primarily due to the fact that it gave the petitioner the right under due process to contest the said evidence, Your Lordships. So here in this instant case, further moving on to section 63, Your Lordships, there is no violation of procedure established by law, Your Lordships. Here, for any evidence to be taken into consideration, there must be a law existent for the same, Your Lordships. If I may guide Your Lordships to section 63, subsection 5, Your Lordships. Subsection 5 of section 63 clearly states, for the purposes of this section, information shall be taken to be supplied to a computer or a communication device if it is supplied thereto in any appropriate form, and whether it is so supplied directly or with or without human intervention, your lordships. This section clearly states with or without human intervention. The counsels for the petitioner had mentioned the opaqueness and the black box algorithm or the black box conundrum behind AI and how it does not have any human intervention, your lordships. The counsel would like to further state that section 63, the objective of introduction of BSA in itself, if I may guide your lordships to the page of objectives, clearly states that the existing law does not address the technological advancements undergone in the country in the last few decades. That was the reason for moving from the Indian Evidence Act to that of the Bharatiya Nyaya Sanhita, your lordship. So in this instant, Bharatiya Saksha Adhiniyam, your lordship. In this instant case, when there is a shift due to the technological advancements, and section 63 subsection 5 clearly states with or without human intervention, your lordships, the legislative intent was to also include evidences that did not have any human intervention in them, such as AI evidences in this instant case, your lordships. The council would like to further go on and state that.
To that extent, you are right. What they are saying is that when you have used those tools without human intervention, which only determined whether it is deep fake or whether the data was correct or not, then you come within the mischief of Loomis is their contention. It essentially decides the guilt or otherwise of the person.
Indeed not, your lordships. In this instant case, the council would like to further state that a deepfake detection report here is provided primarily because it cannot be mere susceptible to human eyes, your lordships. This can be further stated by referring to paragraph number 17 and 18 of the moot court proposition in itself, your lordships, where the evidences of Mr. Gopal, a retired employee who was also caught part of this scam, and Dr. Sarah, a forensic audio analyst witness, was also given in your lordships. If I may read the paragraph number 17 to your lordships.
Yes.
Convenience.
Leak
Just a
movement,
minute, your
yes.
lordships. Paragraph 17 states that the lip movement seemed slightly off when the official was speaking, and Mr. Gopal revealed this in the cross-examination done by that of the petitioners. And here, Mr. Gopal was a very well-known individual, and he was well aware of such glitches or technological advancements that were there in place. But even for such a person, it was not susceptible that he was being part of a scam, your lordships. To further state, in paragraph 18, the audio analyst had given a statement stating that the synthetic voice contained micro patterns consistent with neural voice cloning technology while imperceptible to human ears, your lordships. Here, this AI or the deepfake detection report predominantly does not establish any guilt on the side of the petitioner, but merely states that these deepfakes were used by that of the petitioners in order to scam the pensioners, your lordships. Here, it is nothing but like it can be taken to be sort of a forensic report, your lordships. It can be taken in corroboration with other evidences, your lordships. This AI evidence or this AI deepfake detection report is not the primary evidence against that of the petitioners in this instant case. It has been conclusively determined along with other evidences that the petitioner is at fault here, your lordships. It is not only the AI evidence or the deepfake detection report in question. To further state that
argument we appreciate. That is the argument of your colleague. Now you are here to sustain that AI is also admissible or not. Therefore, do you agree that we can delete the AI evidence and rely upon the other corroboratory evidence?
the council will beg to differ on your lordship's point upon that aspect is primarily because the AI evidence should also be taken into consideration, your lordship.
That's what we are expecting from you.
Yes, indeed, your lordship.
Yes.
The AI evidence should also be taken into consideration, your lordship.
Whether artificial intelligence itself is generated data or anything is fed by the person to hold him guilty.
Your
That
lordship.
we'll have to emphasize.
Yes,
Is
indeed.
that
your
any
lordship.
system is generated him so that it captured and automatically thereafter it generated the data.
Yes, indeed, your
You'll have to
lordship.
come out with clear terms.
Yes, indeed, your lordships. In this instant case, it can be stated that for any AI to work or any computer in itself to work, your lordship, there must be an inputter or a prompter, your lordships. there we can, even assuming that there is a prompter here, where the section itself says with or without any human intervention, even assuming that there is a human intervention, it is the inputter in this set case or the prompter, your lordships. Here, the counsels for the petitioners had clearly mentioned time and time again stating that they had no right of cross-examination. Whereas in this instant case, they have a right to cross-examine the prompter or the inputter. And in furtherance to the same, there was an expert such as Dr. Sarah, who was introduced into that of the stand, who can be very well cross-examined and who was very well cross-examined by that of the petitioners in this instant case. Therefore, the council is trying to rely upon the fact that this was not a decision-making system that automatically derived any results against that of the petitioner. Here, it worked on an algorithm whose source code need not be revealed in the said case for them to rebut the said evidence, your lordships. They have enough amount of opportunity to already rebut the said evidence by cross-examining the inputter, by cross-examining all of the other expert evidences that are being adduced, your lordships. And in furtherance to the same, the council would like to state the case of Wakefield versus New York, where the New York Court of Appeals placed the burden on the defendant to show a particularized need for discovery regarding the software. This is given in page number 41 and 43 of the compendiums provided to your lordship.
Before you proceed, see, you relied upon the preamble and the object.
Yes, indeed, your
This
lordship.
is only to support your case that the validity can't be challenged, isn't it? You relied upon the preamble
Yes,
and also
indeed.
read out section 63(5)
Yes, indeed,
to
your
say
lordship.
with or without human intervention, and therefore the challenge to the validity is can't be sustained, correct?
Yes, indeed, your lordship.
The very reason for now you can't look at the preamble and then say because the legislature intended something, therefore it must be valid. You challenge it only because the legislation which is made apparently according to them offends Article 14 and 21. Therefore you will have to possibly respond.
Your lordships, the council here is merely trying to state that there is no violation under 21, primarily because there is a right to a fair trial afforded to that of the petitioner in this instant case by giving the petitioners enough number of opportunity to cross-examine and rebut the said evidence being posed to them.
That provision which is under challenge.
Yes, indeed, your lordships. They had also challenged the certificate provision under 63 subsection 4 subclause C, your lordships. In that instant case, the council would like to further state the same clarification as the petitioners did before, clarification number 18, where they had 28, where they had clearly mentioned that there was no expert notified as on to the date of marking, your lordships. The council would like to further provide your lordships with the case of Neeraj Datta versus State of NCT Delhi. The council apologizes for having a single copy, your lordships.
Yes.
The council also seeks a time extension of 2 minutes to
Yes.
continue. In Neeraj Datta versus State NCT Delhi, a 5-judge bench in paragraph 64 and the 4th page of the said copy emphasize that the expressions may presume and shall presume in IEA are categories of presumption. Factual presumptions or discretionary presumption come under the ambit of may presume, and legal presumptions or compulsory presumptions come under the category of shall presume. And this can be recorded with respect to section 79 of the Indian Evidence Act, currently section 78 of the BSA, your lordships, where it is clearly stated that the courts shall presume the authenticity of the documents without calling for the expert or without putting the expert on the stand, your lordships. It says shall presume. And it also includes the word certificate in the said provision, your lordships. If I may guide your lordships to section 78.
That's where the argument was. See, your argument is that the AI-generated evidence can be taken as if it is a forensic report, as if it is an expert evidence.
Yes, indeed, your lordship.
Their case is that in a given case, if it is given by a human expert, they can call him to the box and cross-examine. How do I summon the AI and cross-examine is the exact argument. That's what they want me to read down section 63 itself.
The council completely understands this.
Especially in a case of a criminal law. When we are prosecuting somebody, they are saying that the right to cross-examine is a valuable right. And if your argument is that this is like an expert report only, then the expert can be summoned and cross-examined in a given case. How do one, cross-examine the AI?
The council is merely, the council humbly agrees with your lordships on the point that the right to cross-examine is indeed a very important right envisaged under Article 21. The council is merely trying to contend the fact that the petitioners wanted to originally call the original algorithm developers of that of this AI, which is not required in this instant case, is primarily because they have the right to cross-examine the prompter or the inputter, which is the CCW wing officials or the authorities, your lordships. This particular automated decision-making system is under the lawful control of that of the CCW. Any person who inputs or prompts the said input into that of the automated decision-making system can be cross-examined. The right to cross-examine is not being taken away from that of the petitioners in this instant case at all, your lordships. The right to being cross-examined is given to them by the way of cross-examining, allowing cross-examination of that of the prompter in this instant case, your lordships. Council is merely trying to state that there need not be any original algorithm developer that is being called to the stand for such examination. And to the effect of the same, the council would like to further state the case of Wakefield versus New York. Continuing the citation, your lordships, in page number 41 and 43 of the compendium provided to your lordships, it is clearly stated that the New York Court of Appeals placed the burden on the defendant to show a particularized
Can
need
the
for...
courts of Indica place such a burden on the defense?
Your lordships, even in this instant case, there can be a reverse onus of proof or reverse burden of proof that can be placed on that of the defendant when there is a case that is being submitted by that of the prosecution beyond any reasonable doubt, your lordships. In this instant case, the council is trying to contend the fact that presumption of innocence and reverse burden of proof that is being placed on that of the defendant right now does not violate any of his rights under Article 21. In that instance, such a burden can be placed on the defendant in this instant case, your lordships. And to further state that the defendant's arguments for wanting the source code of an AI as the was rejected by the New York Court of Appeals primarily due to the fact that the source code was not an entity to be cross-examined and upheld the advantage of the AI system to produce effective results, your lordships. In further to state the case of State versus Mohammed Afzal, the court recognized the challenges to the computer-generated electronic evidence and the burden of proving the defect defect beyond a reasonable doubt was on the challenging party in itself, your lordships.
Reverse burden, according to you, need not require legislation. It could also be through a process of interpretation.
Yes, indeed, your lordship.
Because there is no legislative provision which provides for a reverse burden in the present case, and therefore you would assume that even through a process of interpretation, court could apply reverse burden, is
Yes,
it?
indeed, your
That's your
lordship.
case.
Yes, indeed, your lordship.
Criminal law proceedings.
The council,
This is criminal law proceedings, not civil law proceedings.
council,
The burden will not shift.
the council,
The burden never shift.
the council seeks for a 30-minute extension to answer your ladyship and
30
lordship's
seconds.
questions. 30 seconds to a minute, your lordships. 30 seconds to a minute, your lordships. Apologies, your lordships. In that instant case, to answer your ladyship's question and your lordship's question, yes, the council recognizes that there must be a specific statutory provision in order to shift the burden of proof onto that of the defendant, like that of the NDPS Act or the POCSO Act in this instant case. But the council is trying to state that when there is proving of the case beyond reasonable doubt in this instant case, where the petitioner was indeed afforded a right to cross-examine, was indeed afforded a right to rebut all of the evidences being posed against him, was indeed afforded the right to even call the prompter and question him upon what prompt was given to generate such an deepfake detection report. When the petitioner had all chances, automatically when the petitioner states in the court, in such a Supreme Court stating that such right has not been afforded to him, the burden of proof falls on the defendant to show that such a right was not afforded to him, your lordships. Council would...
Is it sufficient for you to conclude that you have proved the guilt of the accused beyond reasonable doubt and that ends everything?
Your lordships...
Is it not all right to conclude with that?
Your lordships, when there is special knowledge with respect to that of the
In
defendant...
the absence of any special provision for presuming the initial presumption in favor of the prosecution, in the absence of any special provision, is it not sufficient for your side to conclude that you have proved the guilt of the accused beyond reasonable doubt and there ends everything?
Your lordships, here the council seeks another extension of 2 minutes, your lordships. Yes, indeed. Much grateful, Your Lordships. In section 109 of BSA, it clearly states that burden of proving fact, especially within knowledge, Your Lordships. When the defendant has possessed a special knowledge with respect to not having the right to cross-examine or not having the right to call the original algorithm developer, then the burden of proof falls on the defendant to particularly show us how the said right has been denied to him, Your Lordships. In that particular instance, the counsel is not merely placing her reliance upon the fact that the case has been proved beyond reasonable doubt, so the burden shifts on that of the petitioners. Here, even placing reliance on section 109 of the BSA, the burden does shift on that of the defendant, Your Lordships. Therefore, there is no unfair or unjust burden of proof that is being shifted on that of the defendant in this instant case. And to further go on to state that, finally, that in this case, the petitioner's concern regarding transparency and processes is valid, Your Lordship, with respect to the AI. But in this instant case, AI cannot be taken to impose just because we introduce an AI evidence, it cannot be taken to be imposed unfair or unjust requirements for the original algorithm developer to come to the stand and give any witness or testimony with respect to the same, Your Lordships. And the existing statutory and procedural frameworks do inculcate AI evidence under section 63, subsection 5 of the said Act, Your Lordships. In continuance to the same, if Your Lordships have any further questions, the counsel would be pleased to answer. The counsel would like to proceed to the prayer of the...
Yes.
Wherefore, in the lights of the facts presented, issues raised, arguments advanced and authorities cited, it is humbly prayed that this Honorable Supreme Court may be pleased to adjudge and declare that this SLP is not maintainable, and in furtherance to the same, the order of conviction passed by the Honorable High Court against the petitioners be upheld. The evidence admitted was in accordance with the procedure established by law, and 63 is a constitutionally valid provision. This Honorable Supreme Court may pass any such other order as it deems fit and proper in the interest of justice, equity and good conscience, and for this act of kindness the respondent shall duty bound forever humbly pray, Your Lordships. It was an honor arguing before your courts.
May it please, my lords. My lords, with regards to the maintainability, it was argued that it was for the sake of the moot that they had consented to the even otherwise, my lords, Whirlpool judgment mandates only two essentials for SLP. One is that there should be a substantial question of law. The substantial question of law is that whether 63 shall extend to AI also. Two, grave injustice. The fact that you used an AI evidence to put me through the conviction was the fact that there was indeed grave injustice. Therefore, my lords, it was not for the sake of moot, but the very essence, even in practical aspect, they'd have to consent to 136. Going ahead, my lords, they had relied upon the Govindaraju verdict. My lords, Govindaraju verdict did talk about that you should not adopt an archaic approach towards the policemen and assume that they're always wrong. My lords, true, but you are capable of invoking that defense only when you establish the credibility of yourself. And that credibility itself is in question, and very most importantly, it's upon the judicial discretion to ensure that whether you are credible enough or not. Only at that place you can say that our credibility cannot be questioned and you cannot adopt an archaic approach altogether. And going ahead, my lords, with the audio-video recording of the seizure altogether, my lords, 2 points of contentions we would like to place. One was that there is no record to say that seizure camera proceeding was marked as an exhibit before the trial court. Thereby, it cannot be presumed that it was marked so, and conclusions cannot be derived that it was authentic on that very reason. Second, my lords, even if it was recorded, it shall not record the process of you copying the hash values, and it shall not, and even if it done so, it shall not record that particular finding, and that cannot be under that purview, my lords. And my lords, there was we do not believe if it was intentional. The police witness was called as an independent witness. My lords, police witness is an official witness. Independent witness is a person who is not even concerned to the seizure. You cannot call a police witness to be an independent witness to adduce it all together.
One aspect, see, you are an expert. You have been engaged. You have been worked as an intern to create a specific system. You fed some information in the computer, which resulted in developed the further algorithm and developed this one uniqueness. What is your explanation for what are the information fed in the computer, how it's automatically generated later? Is it not amount to the come under the electronic record?
My lords, if I may please have an extension of 2 minutes to come up with an answer and the rebuttals which we have, my lords.
Yes.
My lords, the first aspect is with regards to our internship at the company at the very self, my lords. My lords, TTPL, we had interned in the company. My lords, a significant question which raises is that if I am accused of stealing data from TTPL, it is clear that TTPL had the data of the government at the first place. There is no point where they had gone ahead to verify as to how did TTPL even acquire government's data. And all of that government, the pensioners' data have to be present at TTPL, which I had stolen. If they say that I have taken it from TTPL, how did a private company get all the records of the pensioners, which was given at a government record altogether, my lords? They have not established that chain either. And very most importantly, my lords, a factual misrepresentation has been done. My lords, it is 8 which is followed by 9. My lords, paragraph number 8J of the proposition reads that TTPL's co-working space was raided on 1810 and seized 4 workstations, 7 hard drives and a server. And my lords, the immediate direct to jump goes ahead to say that Aaron, a graduate of Indica, was with a dual degree, was arrested. Now, my lords, you have not told us how was the connection between TTPL and Aaron established? What did you find? And my lords, worst case is that both of the arrest and seizure was on the same date. Thereby, you did not send that particular report specifically to the forensics analysis, came up with a conclusion, and then went to Aaron's house. Rather, you went on the same day, and that cannot be at any point can be taken as a defense altogether, my lords. My lords, the respondents had relied upon the eridem verdict, whereby only the managing director is held to be liable for a company. My lords, doctrine of corporate wealth shall apply to any director, and if at all it was an intern, the company shall be vicariously liable for not having authorization over the acts of its own employees. You cannot quote eridem verdict to escape yourself out of the liabilities altogether. And my lords, going ahead with the next clarification, my lords, the respondents had predominantly relied upon clarification 6 and clarification 36. My lords, if I may please have your attention to the exact clarification. The question is whether Aaron or his syndicate. It is not whether Aaron utilized the money. It could be any people of a syndicate. You have not established a relationship between the syndicate and Aaron in the first place. You cannot quote that Aaron alone had seized the money altogether. Going ahead, my lords, the penetration testing. My lords, page number 40 bears a sample vulnerability report, my lords. My lords, vulnerability report is where I figure out that there are a few vulnerabilities present in your website. Please ensure that the data is safe. My lords, if you may please have your attention to page number 40, it is a vulnerability report given by Internet Freedom Foundation, whereby a bunch of data by this government was already leaked, whereby 4,000 people's UID data and Aadhaar information was available on public altogether. It was Internet Freedom Foundation which found this, disclosed it with the government thanked them, and all the more they took the data down. This is pretty much what my client also did.
Yes.
Well, with that being said, the last limb of my argument is with regard to their charges, my lords. Section 39 of the Aadhaar Act, if I may please circulate the sections extract, my lords. My lords, 39 talks about tampering government data. I have never tampered. Assuming that I've even gotten inside, it does not talk about breach into the data. It talks about tampering with the data. There is no accusation of tampering at all. Terrorist Act's definition, it's mandating you to use explosives.
But your defense, consistently you have taken a defense that is ethical hacking.
My lords, ethical hacking is very much specific to the public data, my lords. Ethical hacking over here is where I have figured out that your website is vulnerable to being hacked. I am sending you a letter. Please ensure that you take necessary steps. And this is not new. The Indian government has, as in multiple occasions, we have had data being lodged. Until the DPDP Act was imposed, all of these people did not even resort to significant methodologies to even keep the data safe. It was DPDP Act which came and ensured that all of you have to keep your data safe, and please do not let it all together. Puttaswamy judgment affirmed it altogether even before DPDP Act came into force. Well, with that being said, I'd like to conclude that the charges are not essentiated on that particular regards, my lords.
Yes.
Greetings to the bench again, my lords. My lords, they have argued that the entire recovery process by an official witness is archaic, my lords. But by the judgment that I have submitted, which is Bantu applicant versus State NCT Delhi, it is understood that audio-video means came as an addition to the already existing procedures, whereby you view official witnesses giving their testimony and independent witnesses giving their testimony on the same plaque, so that you do not discriminate police officials doing their police administration duty. And the fact that they are claiming that these audio videos have not been marked or exhibited is something that is within their own special knowledge, because it has not been mentioned in the fact sheet. And by by reason of expressio unis, if something has not been expressly claimed in the fact sheet, it does not give them the right to assume that this has not been marked or this has not been exhibited, my lords. And also following down to their entire interpretation of TTPL, the council feels that they have completely misunderstood the facts in this case. It is clearly stated in paragraph 5 that the portal gave access to third parties under the guise of technical consultancy. If they are assuming that the third party is TTPL in this case, that is why the council cited the Iridium case to say that there was no managing director or any person managing the affairs of TTPL to be included here, is because the alter ego doctrine has not been satisfied. Also, my lordships, the council previously and conjunctively stated that it is only if we read it chronologically, there has been no misrepresentation or misleading to the court, it is only if we read the fact sheet chronologically, that once recovery from TTPL's co-working space is done, it automatically went to the fact that Aaron's co-working space is done, a link can be drawn. The council left it to the bench to whether or not the bench wants to accept this argument made by the respondents. The council never tried to mislead the bench. Finally, your lordships, they have stated that we have relied on clarification number 6. My lords, I would like to state that even without reliance on clarification 6, for a second, let the counsel for the respondents assume that they have not used the money. The fact that they employed money mules to withdraw the money, the fact that they changed this money into cryptocurrency itself establishes the fact that they have went way beyond ethical penetration testing in this case, my lords. And finally, my lords, I would like to conclude that since they have not raised any rebuttal on my co-counsel's arguments with respect to AI evidence, the counsels for the respondent would like to very satisfyingly assume the fact that they have been granted all of their rights under Article 21, including the right to cross-examine, and they have successfully rested all of their claims against the AI evidence brought in by the respondents in this case, my lords. It was indeed a pleasure submitting these sub-rebuttals, my lords. Thank you so much for this opportunity.
Thank you. Congratulations for both the teams. Both of you done a wonderful job. You argued well. Results will be known later. Yes.
See, every one of you have argued well, even if the results are otherwise, I do not know. But whatever may be, we appreciate your efforts, sincerely.
On behalf of the Madras Bar Association, the Natarajan Charitable Trust and the organizing committee, we thank the honorable judges for having judged the final rounds. There would be a short break for about 20 minutes before the commencement of the valedictory function, in which time we'll be organizing the stage. We request all persons present to kindly proceed downstairs for the refreshments. Thank you. All volunteers, participants shall proceed to the ground floor, please. All participants and volunteers to proceed to the ground floor. All advocates also to proceed to the ground floor, please. Thank you.